case briefs, and so much more. LSData's got what you're looking for.
In a landmark 1993 decision, the Supreme Court of New Jersey drew the battle lines in a dispute revolving around a general liability insurance policy with a pollution exclusion. The policy was issued by an out-of-state carrier and covered out-of-state operations of a Pennsylvania firm, the Gilbert Spruance Company. This company, a paint manufacturer, had been shipping its waste to 4 separate dumps across New Jersey from the 1970s and 1980s. Now, those dump sites, marred by multiple toxic-tort claims of personal injury and property damage, set the stage for a legal showdown pulling in not just Spruance, but also the New Jersey Department of Environmental Protection, NJDEP. The battle hinged on a single crucial question: should Pennsylvania or New Jersey law govern the interpretation of Spruance's insurance policy? If New Jersey, it would mean that the state's stringent environmental protection laws would apply, opening up the firm to potential liability claims. The legal saga began when the lower court ruled in favor of Pennsylvania law. This decision was upturned by the appellate division, which asserted that New Jersey law, given the state's marked connection with the transaction and the resultant controversy, should guide the policy's interpretation. Cementing this perspective, the Supreme Court of New Jersey agreed, setting a precedent by repudiating the conventional uniform contract interpretation approach. Instead, the court introduced a Section 6(2) analysis to determine the risk location in hazardous waste cases. Applying this interpretation, New Jersey emerged as the principal risk location owing to the aforementioned dump sites. The court reinforced this stance by invoking foreseeability if a casualty insurance policy failed to indicate New Jersey's risk. The Supreme Court's nod to the significant relationship between parties and their transactions reframed the discourse on liability insurance contracts. As such, the case was remanded for further proceedings, reinforcing the primacy of unique, localized factors over uniform interpretations. Though it introduced much-needed clarity, the decision also hinted at the complex legal terrain of environmental policy, where the nuances of insurance law intertwine with the realities of hazardous waste management.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.